Hello, this is Harry Margolis, and in today's lesson in Estate Planning 101, we're going to talk about healthcare directives and HIPAA releases. As you may know, a healthcare proxy permits you to appoint an agent to make healthcare decisions for you when and if you are unable to do so. And it is very important because without that, your family members or the medical professionals may have to go to court and have a guardian appointed to make these decisions who may or may not be the person you would choose. In any case, it creates an extra burden on everybody. So when you appoint your agent, first of all, you can only appoint one at a time, and you can appoint successor agents, but only one person can be empowered to make your medical decisions for you. And they only take office, in effect, when you have become incapacitated. So a medical doctor has to enter into your medical records that you can no longer make healthcare decisions for yourself. Healthcare proxy is used in my state of Massachusetts. Other states have different terminology for pretty much the same document. Some states call it a durable power of attorney for healthcare. So you've appointed your agent. Your agent can make decisions for you on your behalf when you can't. But how's the agent going to make that decision? What factors are they going to consider? Unfortunately, studies have shown that in most cases, agents just use their own judgment, which may be the same as yours and may not be. Hopefully they have similar values. But it's important that you communicate with your agent about what you would want. You want life-sustaining measures under any circumstances, or if you were in a terminal condition or cognitively not intact, would you prefer not to have life-sustaining measures? I mean, right now, as we're recording this, we're in the coronavirus pandemic, and people have different opinions about whether they would want to be intubated and put on a ventilator should the need arise. So it's important that you provide some guidance to your agent, and that can be done in the form of a medical directive. And the medical directive may be a portion of your healthcare proxy, so it can be incorporated into it or it can be a separate document. Different people have different opinions on which they prefer, but it should provide some guidance about really what are your values in terms of healthcare, so that your agent can know how to proceed when you can't direct your healthcare yourself. Related to that, you may have heard about living wills. Living wills are a kind of medical directive, but they're very limited. They mostly just say pull the plug if I'm not cognitively intact or I'm terminally ill, and that's or in a coma, and that's important, but as I said, narrow, and the medical directive can be broader. One way to have a broader medical directive is to fill out a workbook, and there are a number of organizations and agencies that provide these workbooks that ask you your values and your wishes in all sorts of different situations. They often also include questions about what kind of living arrangements you would like. Would you rather stay at home, move to assisted living? What would the options be that you would prefer if needed? And one of these is a handbook or a workbook called 5 Wishes, and you can find it at 5wishes.org. In addition, or instead of the workbook, you can just talk to your agent and talk to your entire family about what your values are and what you would want. And the columnist Ellen Goodman started a program called the Conversation Project at theconversationproject.org that provides a lot of tools for facilitating that conversation, and I recommend it highly. Now, as we said before, the healthcare proxy appoints a single individual to represent you and make your healthcare decisions. But there can be a problem often when relying entirely on just one person, even though you hope that they will consult with other people in the family, they may not be available all the time. And it may be another family member who accompanies you to the emergency room or who's visiting you in the hospital. Now, they can't make healthcare decisions for you, but you want them to be able to communicate with other healthcare personnel and healthcare institutions, and you want those institutions to listen and receive the information that they can provide, whether that's how were you doing before this episode? Were you cognitively intact yesterday, even though you might not seem that way today? What medications are you taking? And there's often a problem of medical personnel being very busy and not wanting to stop and listen to all this. And sometimes they hide behind the Healthcare Privacy Act, HIPAA, and say, well, I can't talk to you. That's a misinterpretation of the act. Well, they can't give anyone else any private information about you. They can listen, but still they can. We've seen cases where they put that up as a protective measure for them from being bothered, and that can be a big mistake. So we recommend that all of our clients, in addition to signing a healthcare proxy, also sign a HIPAA release, which permits communication with whoever you name in it, and you can name any number of people in that. It's not as restrictive as a healthcare proxy where you can only name one at a time. So our clients often name all their family members on the HIPAA release, even though they're only choosing one at a time as their agent on a healthcare proxy. And finally, I want to talk about a couple other healthcare directives: the Do Not Resuscitate Order, or DNR, and the Medical Order for Life-Sustaining Treatment, or MOLST. The DNR has been around for a long time. It's a medical order by a doctor saying, don't resuscitate this patient if he or she has cardiac arrest or stops breathing. And people often put these in place when they're quite ill, and they really don't want to go through what's really often a violent event that can leave them impaired to save their lives in these situations. The MOLST is newer and it's broader. So that's a document you can fill out also with your physician, but after probably a more lengthy conversation to decide ahead of time what kind of treatment you would like under different circumstances. Like, would you want dialysis if your kidneys failed or not? So those are two things that you do with your doctor, not your lawyer, but they're important to know about. So we hope this gives you a grounding on healthcare decision making. And as always, if you have more questions or would like more information, there's a plethora of information on our website at www.margolis.com. And then I answer questions about any estate planning issue that you'd like to pose at www.askharry.info.